was urgent.
It was urgent.
Yes.
So you confirm that what has been written on the record by you saying it was never urgent is a lie.
That's not a lie.
It's misinformation to the court. And in your own words, you were given urgent instructions, correct? Carry on with the reading of your words.
And rushing the same to Aga Khan Hospital for his signature yesterday, 29th May 2019.
Hold on. So you rushed to the hospital under urgent instructions for signature of a will prepared under the instructions of Kalpa and Kishan on the 29th of May 2019, correct?
Correct.
Correct. And confirm that at the time you were meeting the deceased between 1st and the 3rd of June, you had not interacted with the deceased.
I hadn't.
You had not. And that he never gave you instructions for preparation of a will at the time you were taking the will to the hospital, at the time you were rushing to Aga Khan for the signature on the 29th of May 2019. True?
True.
Thank you. Please read paragraph 2 from where you begin by saying, we regret to advise.
We regret to advise. I believe the beginning is imperative to this, so I'll
It's your
read
day in
from the
court, you can
beginning.
read it. You can read it.
In the first instance, a will is a personal and private document and not one that is up for debate or amendment as proposed by Mr. Devani's daughters at Aga Khan Hospital yesterday. Any hint of influence will render the will void.
Carry on.
We regret to advise that the circumstances under which we received instructions to prepare this will and attend to it are less than ideal, given that there is an internal family dispute between the daughters of the testator, Mr. Devani.
Thank you. Now you confirm that you received instructions to prepare the will. The instructions that you received were less than ideal, correct?
Correct.
And these instructions you received from Kalpa and Kishan, correct?
Correct.
Good. And what was your advice after that to your instructors?
Do you want me to read the entire
Yes,
email?
please. Yes, please.
If we are to proceed being aware of the facts as they are, will cause the validity of the will to be questioned and furthermore the integrity of our firm to be questioned.
Thank you. So you can confirm that you had begun feeling the professional pressure of the integrity of your firm being in question.
Correct.
After the instructions to prepare a will of the deceased by other persons other than the deceased in the matter, correct?
Correct.
And after the fact that you got less than ideal instructions to prepare a will and purported interference by the daughters, as you had written.
Correct.
And that is why we're here in court testing the validity of this will. It's before the High Court, you're aware. I believe you testified?
Yes, I did.
You testified, and we are now here. So you predicted all these matters on the 30th of May 2019. Now, please confirm please carry on with the email. Carry on with the email. It is just.
It is just as well that no document prepared by Daly and Inamdar has been signed under these less than ideal circumstances.
Mm-hmm.
Kishan, as you made the introduction, I write to thank you for thinking of us. However, I regret to advise that we are formally withdrawing from this matter.
Thank you, that is enough. Why were you withdrawing from the matter?
I did not want myself or my firm to be involved in such a matter.
Why?
For the very reason we are here today, and for the very reason I objected to this being recorded. The reputation of myself and my firm means a lot.
Yes.
I did not want to be involved in anything like this.
Yes, but you prepared a will under less than ideal instructions.
The one I prepared is here. This one was withdrawn.
Where is the evidence that it has been withdrawn? Where is the proof that the document ever existed in the first place?
I can provide that to you if you really want it.
Do you want to be recalled another day to come and testify?
No, I prefer for this to be over and done with.
Yes, I'd also prefer for that counsel, but you came to court today knowing you're coming to testify. You ought to have brought it in court.
I didn't
So
know
does
that
it
was what you
exist?
wanted to know.
Does it exist?
This will, yes, exists.
And the previous one?
It does exist, but it is
Mhm.
not valid.
It is not valid.
Yes.
Now, read the last bit of your email, the last page from this juncture.
We have no objection to acting for Mr. Devani. However, our engagement will be subject to parameters that will need to be met. We will require independent written instructions from Mr. Devani that he wishes to engage Delia and Inamdar in the preparation of a will, which will only be drawn up after meeting with Mr. Devani and two independent witnesses who will attest that he was compos mentis and lucid when requesting us to draw his will, and that the wishes in his will are indeed his and not influenced by any of his daughters or any third party.
Very well. So you prepared the second will.
Yes.
Confirm and show the court where the independent written instructions from Mr. Devani to engage Dali and Inamda in the preparation of the will are.
On my actual client file.
Have they been brought before this court?
They were not requested
By who?
by anyone.
Okay. And would you wish for the same to be brought to court as evidence?
If the court wishes it so.
Remember when the DCI wrote to you, supposedly, and you responded with your, what you call a statement. Yours was, your heading was request for assistance to the will of the late Devani Balkrisha, correct? Don't
Correct?
you think his written instructions would be part of the evidence that will vindicate and preserve the integrity of your law firm?
The questions he asked, we answered.
Your email says, let Mr. Devani expressly write to us for the purposes of preparation of his will, correct?
Correct?
That email is not before court, correct? But
Correct.
you provided a bunch of emails of up to 124 pages, excluding the express instructions of the deceased, correct?
Correct?
Thank you. And therefore, there was no express instructions from Mr. Balkrishna to your firm for the writing of his will in court today.
That is not correct.
Let's move on. When you were withdrawing from this matter, from the instructions that you got from the daughter and the third party, who is her husband, you specifically indicated for two witnesses, independent witnesses, to attest he was compos mentis and lucid. Is there a reason why you would specify as to his capacity, his mental capacity?
Yes.
Why?
He was in hospital.
He was in hospital.
Yes.
He was a palliative patient.
I did not know that.
He was on morphine at the time you went to hospital. Were you informed?
No.
Good. Do you remember the letter the email that you wrote on the 31st of May 2019? an email that you wrote on actually the one we've been reading on the 31st of May. Did Devani, Mr. Devani, the late, ever fill in the attached add client form?
Yes, he did.
Is it before the court?
No.
Thank you. The question is, the witness had requested the late to fill in a form called add client form. And it is her evidence that the same is not before the court. To the best of your memory, 2019 is a long time ago, but to the best of your memory, do you remember any specific instructions that you gave to Kish? What was your engagement with Mr. Kishan?
In what sense?
Were you friends prior to the engagement of writing his father-in-law's will?
No.
He
was a client of the firm.
He was a client of the firm.
Yes.
So you wrote, his name is Kishan,
Yes.
correct?
Yes.
And you wrote him an email on the 31st of May. Dear Kish, remember?
Yes.
Do you remember specific instructions that you gave to Kish
As you say, it was a long time ago. No,
Mhm.
I don't.
regarding the writing of the will?
No, I
In
don't.
particular, the witnesses.
I do, to the best of my memory, think I requested for the doctors to be present.
In your capacity as an advocate, your instructions were limited to writing the will, correct?
Correct.
Are you mandated to direct your clients on the kind of witnesses that should appear?
In that case, yes.
Where is that provision?
I thought it was prudent.
You thought it was prudent.
Correct.
Okay. And you demanded for the witnesses of the will that you were to draft. Correct?
Correct.
And who did you specify the witnesses to be?
His attending doctors.
And you write, on the witness aspect, owing to the circumstances, the witnesses will have to be, sorry, I don't know why I'm reading your own words. Please read to the court your own email from this paragraph.
On the witness aspect, owing to the circumstances, the witnesses will have to be
Yeah, hold on to that. What circumstances were you referring to?
the fact that he was in hospital,
The fact that he was in hospital. And you demanded the witnesses to be who?
I wouldn't say demand, I would say advise.
Did you write, I advise the witnesses to be, or did you write, the witnesses will have to be?
Will
What
have
was your
to
wording?
be,
Yes.
but that
And
is
we
not
are
a
very
demand.
we are very literal with our words as advocates. You know the import of this email, correct? Who are the witnesses that you wanted to be?
First witness, his medical doctor. Second witness, a close family friend who is a professional of some sort, known to him personally, not related, and not a business associate of any of his children.
Good. So you described to Kish and Kalpa the witnesses who are to be of the will that is before the court, correct?
Correct.
One moment. When you sent the add client form in the first instance, was it signed?
To the best of my knowledge, yes.
When was it signed?
I cannot give you those details. I don't remember.
You do not remember because it is not even before the court, correct? So you want to tell the Honorable Court that you got some interferences from Ms. Dinta, isn't it? Yeah? When you were in hospital. Ms. Dinta was interfering with the discharge of your professional mandate, correct?
Correct.
And there is no evidence to that effect in the court, correct?
There should be.
Please read to the court when you are writing to Mr. Kish, paragraph 5 of your email.
As the introduction was made through you,
Through you being who?
I'm writing to Kish, so through
Okay.
him, we will deal with Mr. Devani and yourself only.
We will deal with your,
With Mr. Devani and yourself only.
carry on.
We will not engage or indulge in correspondence or phone calls from any third party.
So you are very particular that you do not want any correspondences from third parties, correct?
Correct.
And you want to only deal with Mr. Kish and the deceased, correct?
Correct.
Please confirm that you are also communicating with Kalpa in this matter. Kalpa. Confirm whether you are communicating with her.
Possibly.
Possibly is more likely than less likely, right?
She is Kishan's wife, so
Yes.
highly likely.
But you did
yes.
not indicate we will be dealing with Mr. Devani and yourself and your wife.
No.
Good. Now, you are also writing an email, or rather you received an email on the 31st of May 2019 from Kishan Chandarana. Confirm? If
Must
you can
have.
remember.
No.
Sorry?
It was a long time ago, so perhaps if it's with you, then yes.
Okay. And he was asking you to confirm that they are engaging your services to draw up Mr. Devani's will. Right? Yes? Can I read it for you?
Please do.
I confirm that we will engage your services to draw up Mr. Devani's will on professional basis. We also undertake to pay your fees for the same. Kindly confirm this is in order. That is the email. Did you confirm that that is in order?
I may have.
You may have. And therefore, the instructions for writing the will of the deceased were given to you by Mr. Kishan and not Mr. Devani. True?
True.
Thank you. Let's go to the will. I need to seek your clarification for the benefit of the accused and for the benefit of the court, although I am aware the court is well aware of the same. As an advocate, you've done many wills, given your vast experience, correct? What normally happens to properties that have been given during the lifetime of a person?
That would depend in the context that you're asking.
Such as?
They could have been given to the wife.
I'm asking, What happens to properties that have been given during the lifetime of a person? Do they form part of the estate?
If they have not been vested, they can form part of the estate.
Please listen to my question. What happens to properties that have been given or assets that have been vested to someone else during the lifetime of that person? Do they form part of the estate of a deceased person?
Not if they have already
Not.
been vested.
So that is what I'm asking. This answer only requires yes or no. Can you make a property part of the estate of a deceased if it had already been vested during the lifetime to another?
No.
Thank you. During the reading of the will, who informed you that Mr. Balkrishna had passed away?
I do not recall.
You do not recall. But you were never conversing or you never had any engagement with Dinta, correct?
I did.
So do you
After.
remember after
Yes.
after he passed away? But before he passed away, no, after he passed away, or at the time that he passed away, who made you aware that he passed away? Could it be your instructing client, Mr. Kalpa and Kish?
I don't have that information.
You don't have
I
that
don't
information.
remember.
But from the entire family, confirm that you had at all material times been dealing with Kalpa and Krishna. Kalpa and Kishani. Please confirm that at all material times you were communicating and dealing with Kalpa and Kishani.
That is not accurate.
Mhm.
I have dealt with Dinta once the will had been read. Prior to that, I was dealing with Kalpa and Kishan.
So anyone could have told you that he died? Or were you personal with the deceased?
No, I wasn't.
So you were informed that he died?
Correct.
Yeah. And who gave you the instructions to call for the will reading?
Kishan.
Kishan. Were there any conditions for the will reading? Did you require all of them present?
Yes.
You required all the recipients present.
Yes.
Now, confirm Shilpa never came to your office.
She never came.
She never came to your office. So why did you compromise the requirement for everyone to come to your office for the will reading when Shilpa was not present?
Because she was not party to the will.
But she was a recipient of your
Email.
For the will reading, correct?
Yes. Correct.
So if you were the one who drafted, and you kept this will in the custody of your office, so what was the need for informing Shilpa if she was not part of the will?
Precisely that. So it could be made clear to her that she was not a beneficiary to this
And
will.
confirmed that she never showed up in your offices for the will reading.
I confirm that.
Okay. So when were these instructions purportedly confirmed by Mr. Balkrishna for the writing of his will? Do you recall?
No.
To the best of your knowledge, how many bank accounts did the deceased have?
I believe from a response I got from an email I wrote, there was more than one.
Clarify.
More than one.
You wrote to who? Who gave you the
Dinta.
information?
Dinta Patania gave
Where
me
is
that
the email?
information. I can show
Yes,
counsel.
please show us.
Yes. Would you like to see it?
Yes, please.
Here.
So you had a very long email detailing the
Bank
accounts. Thank you.
Correct.
Why were they not specified in your will, counsel?
To the best of my knowledge, that is not necessary.
That is not necessary.
No.
So it is not necessary to indicate what sort of bank accounts or which bank in particular someone is bequeathing.
Not necessarily, no.
What about properties? When you write a will in your capacity as a professional, how do you identify properties? Do you identify by stating the location? Do you identify by title number? Do you identify by the next visible, what's it called? How do you identify properties in a will?
The area,
The
perhaps
area.
the LR number.
Yeah?
Mhm.
The area and the LR number. In the will that you drafted, counsel, did you identify any LR number?
Mr. Devani did not remember them at the time, so no, they were
He
not
did not
indicated.
remember them at the time.
No.
This is a business, a serious businessman, Balkrishna Ramji Devani. If he did not remember them, does that then question his capacity at the time?
No?
And you are informing the court that you were not aware on the kind of medication that he was on.
No.
And you want this court to believe that a man writing his will 2 days or 3 days before his death could not remember the properties he wants to bequeath his children and his family.
He mentioned them by name, not LR number.
So he remembered who is getting what,
Yes.
but he didn't remember what it is he's giving in particular. That is your evidence.
He knew exactly who he was giving what to, which was indicated in the
He
will.
did not know what in particular he was giving out.
Well,
Please
counsel,
read paragraph 8 of your will.
if you read the will, paragraph 8, he says, subject to the payment of my estate duty, if any, deaths, funeral, and testamentary expenses, I give and bequeath all my rights and titles in my 2 properties situated nearby Nyayo Stadium, Nairobi, to my daughter Dinta Devani Patania.
What about the next paragraph?
Subject to the payment of my estate duty, if any, deaths, funeral, and testamentary expenses, I give and bequeath all my rights and title to my property situated in Limuru to my daughter Kalpa Chandarana.
So did he give you copies of the title?
He was in hospital. He
was
didn't
in
have
hospital.
them.
He didn't have them. But he was aware you were coming he was aware you were coming to draft this will, correct?
Yes,
And he was made aware by his children,
correct.
specifically Kalpa and the son-in-law.
Correct.
And confirm that this man was not a lonely man. He had family, he had workers, he had everyone at his disposal.
I believe so.
So if he needed these title deeds, he would have made or caused them to be there when you were drafting the will,
If he wanted them, yes.
if he wanted to. So what I'm saying, or what I'd rather put it to you, is that this deceased person had no capacity to attest to the will that you drafted under the instructions of Kalpa and Kishan. True?
Not true. He gave me instructions. We've been through this before.
He gave you instructions, but they're not in court. So what are we believing? Your word of mouth? You are an officer of the court, you can very well believe that. But you have no documents to show that he sent you written instructions. You have no document or no evidence to show that he filled in the add client form.
Because that evidence was never requested.
But you provided willingly 123 pages of evidence to the DCI at their request.
Correct.
And you never thought that this was necessary? It was never necessary because it did not exist in the first instance, correct?
Not correct.
In your email dated 31st of May 2019 at 11:39, do you recall stating that if Mr. Devani does not wish to proceed, please request him to email me separately and I will advise further? Was
Yes.
the email ever forthcoming? Did
No.
it ever forthcome? It never came. So the email for him not to proceed, it does not exist. The email for him proceeding does not exist. This matter from 2019, at any time you could have emailed the DCI this information that confirms that you really did receive instructions from the late to prepare his will, but you failed or refused to provide the same.
Incorrect. I was not requested to provide that information.
Did they specify the things they requested you to provide?
Yes.
Where is the email requesting the same?
The DCI can give you that.
Where's the email? So when you were responding to the DCI as per your statement, you did not specify to the DCI as per item 1 of what you have asked, this is it. As per item 2, this is it. Correct?
Correct.
So the DCI did not specify what information they wanted from you regarding the will or the estate of the late Balkrishna.
I answered the questions asked.
You answered the questions asked. You have said Shilpa was never in the will, isn't it?
She is referenced in the will.
She's referenced in the will, but she's not an executor or a beneficiary.
No.
And when you received instructions from Kalpa's husband to host a meeting for the reading of the last will, you indicated as executors and beneficiaries under the will, your presence is requested at our offices. Had you ever interacted with Shilpa?
No.
So and who gave you the email belonging to Shilpa?
Must have been Kishan or
Must
Kalpa,
have been
one
Kishan.
of them.
So you are only acting on instructions given by Kishan.
Yes.
and Kalpa. Write the will. We'll pay you. Go do the will. The property is next to Nyayo. The property is at Limuru. Without you making any verification or asking the questions in your professional capacity as to the details of the properties.
Those were asked to Mr. Devani and captured as per his wishes. You do know that a will is a private personal document.
If it is, I know a will is a private and personal document.
Therefore, that is how it
That
is
is
captured.
very correct. But you had written a previous will. Or you had supposedly written a previous will around May 30th before you declined from acting in this matter under instructions of Kishan and Kalpa. Yet you're now here telling us that a will is personal. Why didn't you question them at the time, telling them that a will is personal and therefore that will that does not exist, that is not valid, supposedly, could not have gone through?
It is very clearly indicated in my email to them.
What are the circumstances that made you come back to this matter after you regretted to inform them that you're no longer going to represent their interests?
Mr. Devani's request himself.
He was in hospital.
Yes, he was.
So he wrote you an email, or he came to visit you, or he wrote you a handwritten letter, or did he call you? How did you get these instructions from Mr. Devani?
I do not recall.
You do not recall. So you've come to testify in the capacity of a professional, correct?
Correct.
You've come to testify in the capacity of one who received instructions from the deceased to write the will, correct?
Correct.
But it is your evidence that you do not remember how Mr. The names are confusing. How Mr. Balkrishna gave you those instructions, correct?
Do you want me to elaborate?
You cannot tell the court whether it was a phone call you received, whether it was an email you received, whether it was a handwritten letter you received, or whether he came to your offices to give you instructions.
He was in hospital.
So he did not come to you.
No, he did not come
So
to
how
me.
did you receive these instructions, madam?
Do you want a yes or no, or can I explain?
You can explain.
So, given that he was in hospital, it could have been a phone call or a handwritten letter.
Yes, it could have been. And that
Yes.
handwritten letter is not in court, correct?
Correct.
Nor is any phone call or any document from Safaricom or Airtel, whatever subscription he was using, in court to evidence that he actually called you. So we are not able to ascertain that you got the instructions from the deceased, correct?
You can't ascertain, but I will tell you I did get instructions from him.
Just answer my question so I can move on. I'm asking you, is there any evidence in court to show that you received these instructions from the
I
late?
don't know. I haven't seen the bundle.
You haven't seen the bundle. Is there any way this court can verify that you received these instructions?
Yes.
Without the presence of an email or a handwritten letter or a phone call?
Yes. They can check the add client form.
And it is not before the court. Correct? And in your capacity as an advocate, you know that the court will only decide on what it is presented to. True?
I'm not a court lawyer. Perhaps that may be true.
But you know, you can attest to the court that there is nothing, absolutely nothing, before this court today that shows you received instructions from the late to write his will in court today, as we speak.
I cannot confirm that.
Is there anything to show the contrary?
I can't confirm that either.
One minute.